Circuit Court for the County of Kent is now in session. Honorable Judge Rossi presiding. We are here in the case of Amelia Andrus versus Robert Alt, case number 24-09834PP. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Respondent Alt's motion to terminate an extension or an objection to an extension to the PPO that the court granted. Looks like well, looks like I actually granted the extension, but this is an objection to the extension. I granted it back on March 26th of 2025. So as an initial matter, Mr. Krupp, would you place your appearance on the record?
Sure. Christian Krupp on behalf of the respondent, Robert Alt.
All right, very good. And Ms. Andrus, you have the burden here of proving that the extension was warranted. So I'm going to swear you in and take some testimony. I'll ask Mr. Krupp if he has any questions, and then after that, I can make my ruling. So, Ms. Andrus, if you'd please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I swear.
Very good. And would you state and spell your full name for the record, Ms. Andrus?
My full name is Amelia Noel Andrus, Amelia Andrus.
Thank you. And how old are you, Ms. Andrus?
I'm 18 years old.
Okay. And were you over 18 at the time you filed for this PPO, or were you under 18?
I was over 18.
Okay, very good. And you're the stepdaughter of Mr. Alt?
Yes, sir.
Okay. And your basis for filing this were a series of angry remarks, it seems like, that were made in connection with a dog. Could you elaborate or explain that to me clearly?
Yes. So I got the previous PPO due to his increasing anger and the fact that he was making threatening comments and texts to me about my dog. And I renewed it because I had reconciled with my mother, and he was continuing to have increasingly
I'm going
anger.
to object again because we have people who are in pro per. My client hasn't spoke with her in over a year, so it sounds like we're going to be having conclusions based on hearsay or hearsay. And obviously an improper person isn't going to understand that, but she's going to have to testify from her personal knowledge as opposed to somebody told somebody told somebody.
Yeah, that's correct, Ms. Anderson. You can't tell me anything someone else said to you unless it was a direct statement by Mr. Alt, because he's the opposing party. You can tell me what he said to you directly, but you can't relate any statements from other people. With that being said, when was the confrontation about the dog? When did that occur approximately?
September of 2024. And
Okay.
yeah.
All right. And have you had any contact with your stepdad since that, back and forth?
I have not.
Okay. All right. And do you have any reason, do you have any knowledge where's the dog today as we speak?
The dog is in my possession.
Okay. All right. And do you have any reason based on information you've gleaned from social media or anything else that he's still actively trying he's trying to take the dog back from you?
I have text messages.
And are those from Mr. Alt or someone else?
Mr. Alt.
Okay. And what was the most recent text you got?
Directed to me or the dog between him and my mother?
That was, I mean, dogs don't have titles on them. Whose is the dog as far as you're concerned?
Like, who does the dog belong to? Yes, he's mine.
Okay. You got him. When did you get a dog?
I got him October 2023.
Okay. All right. And were you over 18 at the time you got the dog?
I was not.
Okay. Do you know, did you buy the dog? Did you adopt it? How did you get the dog?
My mother bought the dog for me. And we had a previous hearing about this, and I was awarded possession.
I see. So the dog's already been litigated, as it were, in the context of the divorce.
Yes, sir.
All right. Now, Mr. Krupp believes, did you have a chance to read his argument why I should terminate the PPO?
I have not.
Okay, well, he filed a document here, fairly short, so I'll read it to you here. And it claims that, well, he cites that your mom and Mr. Alt are currently going through a divorce here in Kent County, and that you filed this extension to give your mother an advantage in the divorce matter and moved back into the marital residence, effectively providing your mother with exclusive use of the marital home. Is that what's happening here?
No, sir.
Okay. Is the dog there with you and your mom?
I have the dog, but it's not in that household.
Okay, you keep the dog elsewhere.
Well, we do.
Just for your honor, we did have a motion with Judge McNabb, who subsequently to the PPO, where she put my client back in the house and then had Miss Alt leave the house. So he's now back in the house. So that has occurred since all the filings with the court.
I see. Okay, so he's back in the house, so that's no
He's
longer an
back in the
issue.
house, and I can tell you, my client has no interest in having any. The dog was basically a family dog that she took, and but he has no interest in pursuing anything related to this dog. I mean, it's fine. She can keep the dog. I mean, and there was no, to his knowledge, there's no litigation about it. But at the end of the day, him and his wife decided that's fine. Keep the dog. All's good. So there's no issue with the dog.
All right. Ms. Anderson, when was the last text you received, directed to you anyways, from Mr. Alt regarding the dog?
I changed my number right after I stopped talking to him, so end of September 2024, early October.
Okay. And as we sit here today, are you still concerned that he's going to take some sort of action to get that dog back?
Absolutely.
Okay. What do you base that on?
Text messages that were from him to my mother.
Okay. And were those intended to be conveyed to you in this matter?
I'm not sure what.
Yeah, I mean, did he say to, well, example would be if he told your mom, hey, tell Amelia I'm coming to get the dog, something like that.
No.
Okay. Were the text messages directly related to the dog?
Yes.
Okay. And what is your understanding, without quoting the text messages, of the message that you took away from those?
He said he was going to stop at no cost of getting the dog while my first PPO was in order.
Okay. And that would have been during the pendency. When did you learn of those messages?
Almost ago.
I learned a couple weeks ago.
Okay. So more recently then.
Yeah.
Okay. All right. Mr. Krupp, I'll let you ask any questions that you have.
Sure. Ma'am, you would agree since the PPO was issued, you've had zero contact with Mr. Alt, correct?
Correct.
You've had zero text messages directed towards you.
Correct.
You have had zero text messages.
Not from Bob.
Correct. So
Yep.
nothing, absolutely nothing, right?
Yep.
And you have the dog, right?
Yep.
And the dog was purchased when you were living with your mom and stepdad, correct?
Yes.
Okay. And did you pay for the dog?
No.
Okay. So it wouldn't be too crazy to think that it was a quote family dog, right?
The dog was intended for me.
Okay. Well, according to you, it was intended for you, but at the end of the day, it doesn't.
Okay.
So, and we're not going down the train of so-and-so told so-and-so told so-and-so, because I can't cross-examine them. So, at this point, you've received no phone calls, you've received no text messages, no emails, no communication at all from Mr. Alt, period, let alone a communication directed about this dog, right?
Yes.
Okay. I have nothing further.
All right, thank you. And the only follow-up I forgot to ask, did you have a a hearing in front of Judge Kometz where you went over the facts for this case pursuant to Mr. Alt's motion to terminate the PPO in the first place?
Um,
To my
No,
knowledge,
you dropped it.
yeah, my client said they didn't argue about it because they just didn't care about the dog, so I don't think there was ever a hearing, it doesn't sound like, to begin with.
Is that consistent with your memory as well, Ms. Anderson?
yes.
Okay, yeah, and I couldn't tell from the record, there was a record in there leaving the PPO in place after Judge Kometz did something with it, but I couldn't tell if he had a hearing or not. I just didn't want to contradict any rulings that he had placed on the record. Well, I have heard the testimony today and certainly could see, after all, this is in the context of, and that divorce proceeding still ongoing, Mr. Krupp,
Yes, it is.
but the issue of the dog has been put to bed. So-
Yeah, there's no, my client has no interest in the dog and is not pursuing the dog and doesn't care about the dog. He has other fish to fry because he's going through a divorce with his wife, so.
Okay, well, and my experience is, and of course, I'd like, used to be that dogs were just simply property. They were divided up like tables and chairs and things like that. Of course, you can't give two chairs, two legs of the dog to one person and two legs to another. That doesn't work. It's either the whole dog or no dog. And thus, because of the bonds and the place that animals have in every family, they've rose to levels of more emotional significance. And certainly I believe that was the case here, and thus the original PPO was justified. However, given the fact that the legal question of the dog is no longer a question, and Mr. Alt, through his counsel, has stated on the record here that he has no intention of taking the dog or bringing the dog into his possession any longer. My concern now isn't, my concern before was that the dog was kind of caught in the middle of this divorce action, and that, Miss Andrus did have some legitimate concerns about who the dog would wind up with. It appears the dog's safely in Miss Andrus's possession, and that Mr. Alt is not going to make any efforts to obtain or take the dog away. And that appears to be where the conflict centered, where I extended this PPO. So I will terminate the PPO effective today. I just don't think it's necessary anymore. However, Ms. Andrus, based on the prior PPO, if you receive additional threats or things that make you concerned, you're always welcome to come to the PPO office and file for a new PPO. Just reference the fact that you filed for one before, and then I take into consideration the facts that justified the prior PPO in deciding, or another judge would do the same. So that door remains open, but I'm glad the issue of the dogs have been resolved, and wish you all the best both this weekend and going forward. Thank you.
Thank you. Have a good weekend.
All right, we have both parties on the 245. Good afternoon. Can you both please unmute? Okay, and you can hear me okay?
Yes.
Oops, sorry, I didn't hear you.
Yes.
Okay. That was a little bit faint, so you may just have to speak up or move a little closer to the mic as we get started.
Okay.
Oh, that was better. Thanks. We are here in the case of Christina Munoz versus Jacob Bennett, case number 25-034223PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Mr. Bennett's objection and request for termination of a PPO that I granted in favor of Miss Munoz. It appears that I granted that protection order back on April 15th of this year. So as an initial matter, I do see both parties are here in person. I would ask you both to state and spell your name for the record. We can begin with Ms. Munoz.
Sure. First name is Christina, Christina. Last name is spelled Munoz.
Thank you. And Mr. Bennett.
Jacob Bennett, JACOB BENNETT.
Thank you very much. And Ms. Munoz, this is your PPO, so you do bear the burden of proof. And what I am going to do is I will swear you in and take your testimony. I do have to give Mr. Bennett the opportunity to ask any questions by way of cross-examination he may wish of you, and then I can make my ruling on whether or not the PPO will remain in place. So, Ms. Munoz, if you would please unmute and raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right. Ms. Munoz, I do have your PPO in front of me here, and I believe it was me that signed this. Yeah, I did grant it, and it is what we call a PH order based on a fear of a sexual assault. And I do have your statement in front of me here. Without just reading the statement to me, why don't you state the basis that I granted the order for at this time?
Say is repeated behavior that is unpredictable and changes by day, by week, by hour, that puts my life in danger and has created a hostile environment for my education and my employment. And there's no freedom, and it interferes with my liberty to do my job and to go to school and to participate in my life. There's a threat to either hurt me or kill me or sexually assault me if I refuse to submit to his wishes, whatever it may be. And there's no regard for another person's emotions, rights that I've seen throughout the last several months.
Okay, and you are live in the same apartment complex?
Yes.
Okay, and the most concerning incident as I'm looking at this is one that was the basis of the police report. It looks like you say on January 9th of 25, he grabbed your chest butt when you told him no several times, and then subsequently on January 11th coerced you into sexual intercourse after you said no 20 times in 3 hours. Those statements are true?
Yes.
Okay, all right. And then subsequent to that, there were a series of interactions that you had with him that made you fearful of Mr. Bennett? You had some contact with Mr. Bennett?
Yes,
that
there
made
is
you fear?
repeated text messaging requesting a date and romantic intentions, and I kept saying no. And he would become angry and almost violently angry, going from calm to angry in a matter of seconds sometimes, that after I've denied the request and then further pushing towards what he wanted. My no and my boundaries are constantly violated. And this is wherever I am. And I've run into some other neighbors in the community, and he soon appears thereafter. It's very predictable. There's a correlation there. Can't say it's causation, but I do know that these incidents are connected with some alliance with the management of the apartment company, in terms of making it harder for me to have any freedom or any kind of sense of safety. Without hearing my side of the story, it's always very one-sided, and several people have been turned against me, and making it seem like I'm the problem as opposed to the one who's been repeatedly victimized in the situations where I've had to hide and try to find alternative housing and try to hide my dog to keep her safe. Simply because I say no, it's not respected.
Now your PPO references a police report of this year.
Yes.
Is that still under investigation? Do you know?
No, it is not under investigation. There's been additional comments have been added to it after April 1st, though.
Okay, which one is with
Okay, and in other words, I mean, now of course I'm going to ask Mr. Bennett this as well, but I mean, he hasn't been arrested or charged that you're aware with the sexual assault?
No, was not charged, no,
And it
not in a
looked to me,
criminal court. Go ahead.
okay, no, yeah, I get it. And I looked to me like was there a dating relationship at some previous point or never?
No,
Okay, all right. Okay, well, Mr. Bennett, I'll give you an opportunity to ask Ms. Munoz questions at this time.
Yeah, what's your proof? We live in an area
all of the
with,
text messages from January 8th through 9th, and eventually all the text messages from January 9th through this all the way ideally until the 20th, and when you burned the apartment down.
gotcha, but where's your proof? We live in a very well documented and camera recorded environment. You don't have
The proof is
anything?
in the message, the repeated questioning, the
Oh, I
constant
know,
gaslighting,
I submitted my text too.
and the corresponding inconsistencies in personalities and behavior that misalign with the text messages or align with the text messages precisely. There's a different personality every 3 hours or even within the same day. You can go from acting like Martha Stewart to your father to a frat boy within 3 hours, which is terrifying. Different values, different insight, different ways of speaking, different jargon, and zero right for the moral boundaries and ethics of other people, disregard for other people's lives, no empathy, glib, superficial charm, and just a complete violation of other people's rights.
Okay, so all the friends and community I've built here at this apartment building, they're being suckered, right?
No, they're being fooled by your different personas, personalities, antisocial personality disorder, sociopathy. The first day we were in an apartment group meeting, you told everybody about necrophilia and Oedipus complex. You couldn't understand why we were all uncomfortable with Oedipus complex and necrophilia, because that's not normal for somebody to laugh at that or think it's casual conversation. That's disturbing. That's very Ted Bundy.
Okay.
All right, so no further questions, Mr. Bennett?
Nope.
Mr. Bennett, are you aware of any charges that stemmed out of the allegations that she makes here that you touched her chest and butt when you told him no?
Yep, I'm aware. I was called by Detective Joe Parsley. I went down, I was questioned, they took my phone, they submitted all the text for evidence, and then I believe that was towards the end of the week when they submitted my phone texts. And then by Monday, I was informed that the prosecutor was not following up on this.
Okay, so as far as you know, that investigation has closed without any charges.
Correct.
Okay, all right. And you deny that unconsented touching occurred on January 9th and the 11th?
Correct.
Okay. All right. Well, the issue here is a PPO based upon, and I guess the next question to you, Mr. Bennett, are you crossing paths with Ms. Munoz on the regular basis because of you living in the same, I mean, do you have to see each other?
Fortunately, we have not crossed paths in some time.
Okay, all right. So in other words, you can stay away from each other if you choose to avoid.
Correct, but the leasing office will not let us live here with a standing PPO.
Will not allow the both of you there?
Correct.
So if they filed a motion, I mean, the PPO's been in effect since
Yeah.
April. They've
They
tried
sent out eviction notices, yes.
to you.
Yes.
Okay, and that's because did they tell you the basis for the eviction?
Yeah, so there's a standing PPO and they're also building, there's also been a number of complaints against Miss Munoz. And they are handling it with their legal team, but basically how it was put to me is Their legal team wasn't picking sides, so we both got the same eviction letter.
Is that correct, Ms. Munoz? You've also gotten an eviction notice in the matter?
I did, but because against the Violence Against Women Act, the judge says I am free to break my lease without financial penalty. That's what the lawyer, their lawyer, said I can break it without financial penalty, but I also have an ESA, an emotional support animal, so that would be
Yeah,
that
another
would,
consideration there,
right.
but I mean, in effect, the apartment notice was kind of neutral. They said, well, there's a PPO in place and we're gonna boot you both out.
Correct.
I don't know what other people have received because I can't be told that
Sure.
by a
No, I
manager.
understand.
Yeah.
Okay, all right. Well, I have heard the testimony of the parties today, and of course, the burden of proof for a PPO is much lower. In a criminal case, in order for that criminal case, for example, for the sexual assault to move forward, there would have to be either substantial evidence or to convict at trial, evidence beyond a reasonable doubt that the assault occurred. For a civil case, however, it is just a standard of more evidence than not that the contact occurred. And I've heard from both parties at this time, very intentionally, I didn't want to dig into the details of the alleged sexual contact in January. And that's very simple. The reason for that, Mr. Bennett, is I don't want anything, at worst, a PPO is okay. You got evicted from your apartment and you can't be around a person for the duration of the PPO. At worst, on a criminal sexual conduct case, you go to the Michigan Department of Corrections for a number of years. There's no comparison. In other words, I wouldn't want to get a single word of testimony in a hearing like this that would potentially hurt you down the road. Because frankly, the statute of limitation on that sort of case is a number of years or life in some cases. So I certainly don't want to put either party into place. Thus, I only have limited information to go with here. And I can tell from reading this that there has been friction in this contact and relationship between the two of you. Seems to be exacerbated maybe by the relationships in the apartment, but I do have to view it also from the viewpoint of the petitioner. That is, would a reasonable person in Ms. Munoz shoes have fear that a sexual assault might occur in the future, based upon her allegation that unconsented contact occurred in the past. And I can find by a preponderance of the evidence here that her fear is reasonable enough to support this PPO. Thus, I am going to deny the motion to terminate the PPO and leave this PPO in place. I do note that by its own terms, the PPO is in place until October 14th of this year. At which time, if there isn't any further contact, it'll just normally expire. If there are additional instances of contact, Ms. Munoz can cite those and ask for an extension of the PPO, and I'll make a decision. And you can also object to it at that time, Mr. Bennett. But at this time, I'm going to find by a preponderance of evidence that there is enough for it to remain in place. But that's just like I say, a preponderance is just a little bit more, than not evidence there. And it also has to be from the perspective of a reasonable person, which
Your Honor.
Yeah, go ahead, Mr. Bennett.
So the text I submitted clearly showing that she's the harassing party. Don't mean anything like I'm gonna lose my home based on a few words she said when she was angry.
I did. You actually didn't look through the text. They look like they all predated the issuance of the PPO.
Correct.
Okay, well, and which one, why don't you point me to one of the texts that you think I ought to look at? I guess I can look at a little
Well,
more.
they only let me submit 10 pages,
Yeah,
and it is 10 pages worth of repeated attempts from her side to try to get in contact with me well after the dates of said event, and me confirming that I do not want contact, do not talk to me until I finally and ultimately blocked her.
okay. Now, at the end of this, I did note that there was a it looked like, and I have to be honest here, I didn't read all 10 pages of just because my time's constrained, and it's in very small print, which is harder for me to read. However, I did note that there was one at the end here where she sent a message that said, "I never want to see your face again. Please stay far away from me, and those I love." That looks like she broke contact as at least in March, but you're saying between then and March, there was this back and forth that doesn't indicate someone who's in fear of sexual assault. Is that?
She also would leave gifts at my door, and I know it was her because she signed them, as well as a love letter note also signed. And there was a tub of ice cream I've since thrown out with a sticky note, also from her, confirmed by leasing office footage after she lied when I said, please do not leave things at my door anymore. She lied about leaving the ice cream, and I confirmed with the leasing office that it was in fact her. And I submitted a formal complaint to the leasing office.
Your Honor, I object. That's a lie. That was before. And some of those objects were left by other apartment staff, and the leasing office specifically is in alliance with some of those men in the building. I mean, he's denying that any of the things that have happened on January 9th or 11th didn't happen, but you can prove it. You can look at it through the text messages that he, in fact, did coerce me into sexual contact. On the 9th, he repeatedly grabbed me after I told him no. And he's even, there's other apartment men that have told, as I've written into the explanation that, like,
Well, I
including
can't,
Mr.
I can't
Bolduc.
take word from anyone else because that would be hearsay here. Where in these messages does he indicate that there's the unwanted touching occurred?
Well, that happened in person.
He didn't submit anything, Your Honor.
No, he changes
Okay.
his story. I've ran into him at least 3 times since this PPO, and third parties have basically coordinated his appearance shortly after I run into them, April until May. I've moved into another apartment because of my fear of safety.
You moved to another apartment in the same complex?
Yes, within the last week. I don't live there anymore because we're not safe. My dog and I are not safe.
The events of January 9th had you so scared to pull out a PPO, but you're texting me well through
Your
March.
coercion.
Okay, well,
The stress response is spawning.
what I haven't done at this point is I admittedly haven't read through the entirety of these text messages. I do have a minute here. I'm going to sign off for just a second, go through the text messages. I'll let you both wait. And then I will come back and let me read the text messages. And if I have any questions, I will come back at you. So just let me mute myself for a second here and read these. Okay, I've had the chance to review the text messages at this point. I do have some additional
Judge,
questions.
let me
Okay,
get
let's
us
go
back on the record.
Yeah.
We are back on the record in Munoz versus Bennett, case number 25-03423PH.
All right, and Ms. Munoz, I did have a chance to review the text messages that Mr. Bennett attached. Did you have a copy of those as well?
Yes, and I can show those as well as all the other behaviors that he's participated in outside of that are on camera, that are on video.
Okay, what are those other behaviors that you're talking about?
It's showing that he's turning the management and the community against me. He specifically told certain neighbors that lies about me to say that I'm the problem. As you can see, he doesn't take no for an answer and will try to distract you with other evidence that is twisted and manipulated to get his way. He doesn't want to hear no regards to anything that he wants. So he will force his way into violating boundaries and pushing people to say yes when they mean no. He was befriending Mr. Bolwag, who I went on a date with, and he's destroyed that relationship effectively, along with a superficial smile, because that's not an appropriate motion for the situation, which shows you the lack of empathy and disregard for other people's emotions and lack of compassion. And there's this constant flip in personality that is impulsive and deceitful. And my background is psychiatry. I can see it within every 3 hours to 3 days. There's a different personality. It goes consistent with the drug and alcohol use, that which he's at risk because he's burned our apartment down once, and he's at risk again if he was drinking at that event and could burn our apartment down another time. And just a reckless disregard for the rights of others, because what he wants is is what he's gonna force his way into getting what he wants, whether it's sex with another person or forcing someone to believe something they don't want to believe.
I see, but I mean, I guess my thinking is though is, after looking at these messages, my concern isn't with anyone else. It's that he can't coerce or force you to do things that you don't want to do. Because after all, personal protective orders are personal. I mean, it only impacts his contact directly with you. And I mean, it sounds like, I mean, and after I read through these text messages that say it started like what I'm going to describe as a friendly relationship and then deteriorated. I mean, you've learned your lesson. You're not going to have anything to do with him going forward.
Right. Yeah. And right now there's still third parties posting social media messages that isn't checked off in the PPO regarding Mr. Bennett that are turning other people away from me. So there's a third party. He's using third parties to post social media in a way that would make me feel terrified. I
What
can't
is
You
study
submit
there.
that to court?
Yeah,
What's
I
that?
mean, well, yeah.
Where are you going with this?
Well, I can't take it as hearsay evidence. I guess I need to know what he's posting that makes you fearful or feel harassed.
These are
And
neighbors that are posting regarding his relationship with Mr. Bolwag and other neighbors. This is things that have other people have posted within that friend group that I had left. We were part of the same group chat. I left the group, left all of them, and now they're posting things about him and me and other people there that which just shows you to it just
Well, I
shows you
guess
that
that,
that's how he's
if
violating
I
it.
can just pause you, but is he posting things like I'm going to get back together with her whether she wants to or not, or is it stuff that's just more
It was regarding his intrusion into my relationship with Mr. Bolwag, and they're arguing whether or not Mr. Bolwag and Mr. Bennett are friends.
yeah, and I
It's
really can't find that as a basis
yeah,
for a PPO
but
here. I
he's
mean, I get
repeatedly
it.
showed up in the elevator when um I've I run into the group, so I've avoided the group so I don't run into him in the elevator outside with his dog. I have to basically survey the environment to make sure that he's not around and avoid all possible exits and entrances that he could enter. Um, these are not his community members. This is his narcissistic supply. I mean, he
Yeah,
just takes
no,
advantage of people.
yeah, I get it here. Well, and I mean, doubling down on my concern here is, it's never my intention. I don't have any problem with issuing a protective order to, um, keep people apart from each other. I think that's a good thing. They're called peace bonds, when they originally were invented, the idea being to keep people from taking matters into their own hands and becoming violent, and fighting, as opposed to, just getting an order in court and saying, hey, we're going to keep our distance for X period of time. My particular issue with this one is it is based on a fear of sexual assault. And though I, don't place any doubt that there was contact between the two of you, it's also very clear to me that there are two different stories here. That, in Mr. Bolwag's mind, it was a consensual meeting, and in your mind, you were coerced or, unconsenting participated in it. And that's of course, in any case involving two individuals who are the only two to be witnesses to those such things. That is, however, in this case, I do have the back and forth in these text messages that indicates that at least during that time there was a friendly or somewhat flirtatious conversation going on between the two of you, and that the evidence shows that that went south at the end. The relationship deteriorated and ended very clearly with Ms. Munoz saying no more contact. So what I am going to do at this time, and it is somewhat unique because the order does, in this case, it anticipates not only not that you should have contact with each other, because I don't think you should, but this one says no sexual assault. Well, I don't think, because I think, Ms. Munoz, you have, as you've identified on the record today, identified, to Mr. Bennett that he is not a person that you want to pursue, a romantic or a physical relationship with any further. And it appears that he says the same. And I don't see that these actions, though they are irritating, arise to a legitimate threat of sexual assault. So I'm going to terminate this PPO based on the threat of a sexual assault. I just simply don't think that is there currently, particularly now, essentially 6 months after events at issue and um, going forward. I do think it's in your both interest to watch out for each other. I hope that by pulling the protective order out, perhaps it gives you both a chance to stay in the apartments. It sounds like you both have separate beefs with the apartments, but maybe you can stay. Let's do that. However, if there is threatening or harassing conduct, which is more what you're talking about, Ms. Munoz, going forward, the PPO office is open and if conduct, would legitimately make you feel threatened or harassed, either of you could file in order to, formalize that and make it so that you would have to stay away from each other. Now, I don't know, every apartment has different policies. Some, I know I've modified some in the past to say, well, in particular in the case of neighbors, well, there's no way you can stay out of sight of each other. But you can keep within 300 feet of each other. And coworkers, also, I've granted these, and I say, kind of respect the other person's bubble, like that's around them. Don't unnecessarily come into contact with them. I think you're both going to be best off with that going forward, both in the chance of you remaining at Studio Park, and then, just for the peace in general. With regard to social media, my usual advice to people is, there's so much untruth, mistruth out there, and it's also so hard to know if a message actually originated with a person or not, because anyone can post anything and under any name basically. Sometimes it's best just to take a break from social media, to let the situation kind of reach a level, and then re-engage in a way that builds things up rather than seeks to tear things down, because social media, and I confront it in all sorts of cases, is notoriously both unreliable and unfortunately almost unerasable. When someone puts something out there, it's out there forever. So just some good consciousness about thinking before you post stuff, particularly what can be viewed by the public. I have to worry about that, of course, in my position as well, the statements I make. So, but what does impress me from both of your conduct at the hearing today is you're both people who can, state and resolve your things civilly. I don't think this is a situation where the two of you are going to get into a fist fight in the hallway or something like that. But if that situation does, present itself as threatening down the road, we can just formalize it with another PPO. But I appreciate you both coming in and testifying civilly today, and appreciate, again, the evidence presented. And like I say, let's go forward with no PPO. I'll enter an order terminating it at this time. We'll see how that shakes out. And like I say, the PPO office is open if either of you feel that there is a need for one down the road. So
Thank you, Your Honor.
thank you.
Do we leave now or?
Yeah, we're concluded.
Oh, okay. Have a good weekend.
Now then, let's pick up Abel Estrada Jr. Mr. Estrada, you'll need to start your audio and your video.
Yeah.
Okay, all right. We are on the record in 2024 TR 617. State of Kansas versus Abel Estrada Jr. Assistant County Attorney Paul E. Dean for the state. The defendant appears in person and pro se. The defendant, let's see, this first appearance back in October of 24. After being dismissed and refiled from municipal court. and some failures to appear. Then we had a bench trial February 14th, 2025, and the defendant was found guilty and ordered to pay $108 in court costs and the scheduled fine, with the court specifically ordering that if he appeals, an appeal bond set at the amount of costs and fines had to be paid before or at the time of the appeal. We had a peer review February 28th, 2025. Somehow he was attempting and made some efforts to file the appeal without a bond. He had gone through a couple of attorneys and then ended up
Good.
representing
Trying
himself.
to also determine whether he's actually properly docketed it. He's told us that he has. He's told us that he's talked to people in the clerk's office and that it's taken care of. But to date, there is not one piece of paperwork in my file that shows anything from the Court of Appeals, which we would have received electronic notification. Should have received notification of the docketing, should have received notification of the motion that he filed to waive for the Court of Appeals to waive the appeal bond. I believe you referenced something of that nature several times. I may be mistaken on that.
That's why I was walking through the history. That's what I'm finding too. When he was here May 9th, 2025, another payer peer review. Let's see. The defendant said he is outside the jurisdiction of this magistrate as he is strictly under the appeal court authority, that he had an appeal court case number. So I could not enforce the order for appeal bond or sentence, basically. So, have you paid? It does, Mr. Estrada, did you pay the fine ordered of 158? The court file says you haven't. Looks like you had 108 court costs and a $50 fine for illegally display of license plate or not display.
Your Honor, I take that back. I think my office has finally found something.
Okay.
It just has not, the paperwork has not hit the file. Looks like transcript's been completed. Oh, well, table. Okay, we did receive, apologize, notice, court docketing notice, appellate court docketing notice. So I think actually at this point in time with that, and that, I don't know why it took so long to get to us, but with that, we can remove this case from this docket and we will take care of it at the Court of Appeals.
Let me see if I find everything. Okay, suspension.
I will have my office, I'm going to ask them to file that of record in this, at the trial court level. That way we have that in there. Judge, you don't see, you can't see that from your end?
Well, let me see. I'm seeing the transcripts.
And we did receive a letter. It's probably an emailed letter, but it is appellate court case number 128,986.
Okay.
So
Okay, I did find it. Thank you.
Current
please.
jurisdiction at this point in time from the district court. From the district court.
Okay.
So.
All right. Well, we will just wait and see what the Court of Appeals thinks about your conviction, and I guess they're not going to enforce the order to pay the bond. So if the Court of Appeals decides that piece of paper was sufficient for requirements of tag violations, they'll let you go and it'll be over. But if they find that the conviction should be sustained, that that piece of cardboard that you bought from someone was not a legal tag, then they'll let us know and you'll still owe that money. Now, what I'm wondering, Mr. Dean, I think we might need to look at what appears to be some suspensions on his record for not payment, because if those suspensions for non-payment were filed by our county clerk or our district clerk after the appeal was docketed, those may need to be revisited. If they were done by the Department of Revenue in Topeka at any point in time, I can't overrule or override them. You have any thoughts on that?
Your Honor, I don't know who would have initiated that, because the case had been on continuance. I mean, I think the order's quite clear in this case. They would have received that notice of appeal. So I guess we just need to reach out to the clerk's office. If Missy, if you could reach out to them on that, maybe we can find out an answer to that. I would agree there should be no suspensions as a base from this case, because the Court of Appeals has indicated on the letter that I just saw that they considered it properly, timely docketed. The appeal is timely filed, so there should be no suspensions as a result of this matter until we're back here or the Court of Appeals says that it's overturned.
But Mr. Estrada, you might be mindful and check your driver's license and see if the status is suspended, because it could cause you some grief if you're out there driving around with a suspended license, even though we may be able to clarify it eventually and correct if it needs correct it eventually, but it could cause some headache for both you and for this court and the prosecutor having to come back and visit that. So,
and Mr. Estrada, why I've asked the judge's administrative assistant to check with the clerk's office, because she's right down the hall from him. I think it would probably also behoove you to contact the Kansas Department of Motor Vehicles and question them about that status. You may find it easier to send them a fax, because they're quite difficult to get to get a hold of anybody by phone. In any event, that's all I have, Your Honor.
okay.
Well, I did get 3 different letters saying that I needed to pay, and I called them and I told them that I'm already in the appellate court, and there's no reason why I should be suspended. Is this gonna cause me any more problems? Is this something that I can call you back so you can confirm to whoever I'm talking to?
You don't need to convince me of anything on that issue. What I'm telling you is I'm agreeing with you, but the state of Kansas, for some reason, has a different opinion, and I think they're wrong. I'm just telling you, you ought to probably reach out and try to speak to them further yourself. Perhaps send them a copy of the appellate court docketing statement, things of that nature. Maybe that'll help clear it up for them.
DMV, okay.
All right, Your Honor. Can we take a short break before we get into our 10 o'clock? I don't have anything further.
All right. We're just gonna hold tight until the appeal is done. I'm not gonna set another case this time, Mr. Estrada. You're excused from today's hearings.
All right, we're back on the record with State versus Carly Meyer, 2 cases, 25 CR 192 and 23 CR 300058. Have counsel and state their appearances, please.
Chair Revere on behalf of the state.
Your Honor, Darren Patterson appearing on behalf of Carly Meyer on both cases. She does appear from the Butler County Detention Facility. Judge, as we have noted earlier in the 25 case, there has been a plea already to count 1. Judge, in the warrant to show cause case, I would tell the court that Ms. Meyer is going to waive hearing. She is going to stipulate to the violations that are listed which includes failed to pay fines and costs, failed to refrain from purchasing or possessing alcohol or illegal drugs, failed to report to court services officer, and failed to complete the alcohol drug evaluation and recommendations.
Very well, but Ms. Meyer, have you heard what Mr. Patterson has told me?
Yes, Your Honor.
You understand you do have a right to a hearing where the state would have the burden of showing by a preponderance of the evidence that you violated the terms of your probation?
Yes, Your Honor.
And with a stipulation, you'd be waiving your right in that regard?
Yes, Your Honor.
Have you had sufficient time to discuss this with Mr. Patterson and make this decision?
Yes, sir.
Has anybody forced to coerce you in some fashion to enter this plea?
No, sir.
Very well. I will accept the stipulation, find the defendant has violated the terms of her probation as alleged, and I'll hear from the parties in regards to recommendations, how to proceed. And then we still have the sentencing to do on 25 CR 192 as well, I believe.
Judge, did you want to hear recommendations on both cases?
Yes.
Okay.
And does the state wish to release any witnesses?
Your Honor, if the court has already accepted the stipulation in 23 CR 300058, the state does not anticipate proceeding to an evidentiary hearing under those circumstances.
All right. So I assume Ms. Wheeler was going to stay. Mr. Smith, you're welcome to stay or go if it doesn't sound like you're going to be necessary as a witness. So,
Thank you, Your Honor.
thank you. Very well. I'll begin with the state.
Your Honor, my understanding is there may have been certain plea negotiations between my office, specifically my colleague, Ms. Norris, and Mr. Patterson. The state would respectfully defer to counsel for the defense in these matters.
Your Honor, there are certain plea negotiations that have been memorialized in a email between Ms. Norris and myself. I would tell the court that the agreements between the parties are as follows. In 23 CR 3058, the agreed recommendation to court is that there be violations are found, that she be revoked but then reinstated for a 6-month extension of probation, that she receive credit for time she's been in jail, that she obtain a drug and alcohol evaluation and follow the recommendations of the same. And then in 25 CR 192, that there be a 6-month controlling sentence in that case, that it be consecutive to 25 CR 192, that should be placed on a 1-year reporting probation with all standard conditions. No fine, but there would be a $100 domestic violence fee. The state has no objection to lifting no contact order with her mom as long as all contact is peaceful and non-violent. No drugs or alcohol. That she either obtain a mental health assessment or continue with her current therapy and medication management, follow all recommendations, and take medications as prescribed, which I think is a pretty important one. That the court consider the attorney fees. There's been no request for restitution. And that between the two cases, that she received credit for being in jail. However, they're split up. She's been in jail currently since April 29 to today's date.
Ms. Mayor, is there any statement that you would like to make before I pronounce sentence? or my rulings?
Yes, sir. I just feel like now is a good time to really focus on myself. Before I was worried about prior court dates and court surrounding my children, and now I feel like it's a good time to just focus on my mental health and my drug and alcohol treatment, and really just do it for myself and, you know, to not get in trouble anymore. I also before I had come here, I was in the mental hospital, and I finally have like a proper diagnosis, and the medicine that I've been taking has been like seeming to work as far as like regulating like my moods and like some thoughts that I have as well, and I've been on that for about a month now since I got out of the hospital, and it's been seeming to help.
All right. Well, I'm looking at when you were, looks like you were placed on probation on March the 4th of 2024. With a 6-month controlling sentence. What was the nature of the new diagnosis, and what medication have you been prescribed?
I was diagnosed with schizophrenia, and I am currently on risperidone.
Well, Ms. Mayor, you were placed on probation. Looking at Ms. Wheeler's affidavit in support of the revocation, which was filed, looks like in November. Yes, November 25th of 24. It looks like you had a few months, and then basically you weren't showing up, you weren't, didn't go to treatment.
Your Honor, this is her second warrant to show cause. That was the first request for revocation. There's no journal entry on the first revocation hearing that was done back in December
What year?
of 24. It was December 20 of 24. That was the first revocation hearing.
So the newest motion to revoke was filed, or the warrant to show cause was filed May 21st of 25. Again, failed to pay, failed to refrain from purchasing, possessing, or using, failing to report, failing to complete an updated drug and alcohol evaluation. So this is the second revocation for those circumstances. Is that correct?
It is correct, Your Honor, and she does acknowledge she had a previous warrant to show cause stipulated, received a 17-day sanction, and placed back on probation at that time. And Judge,
Yes.
I'm sorry, appropriate time, I did have some additional comments. The only thing I had addressed court with is just the agreement so far.
All right. I'm sorry. If there's additional statements, please go ahead.
Thank you, Judge. And the court, I think, has reviewed the case pretty thoroughly at this point, that there was a previous probation violation. Now this one, essentially pretty much the same things, but as the court also knows, she had another case before, Your Honor, that had to do with her children. And I think the court does know how that case ended up and turned out. There, in talking with Miss Meyer, she had the stress in her life was tremendous. I mean, I can't think of anything more stressful than having to be involved in a case where you might lose your children. So that, I think, was causing her stress. Her mental illness issues that were undiagnosed, I think, probably also kind of was involved with what happened with her kids as well as these cases to get them finally diagnosed. It gives her a chance to be successful in life. So with this and the medications, she is in hopes that she can have that opportunity then to show that the medications and diagnosis are going to make a difference and allow her to go forward and be productive. She, of course, won't have the stress of a sink case over her head at this point going forward. And as she said, concentrate on her own well-being. So we're just asking the court to consider one additional opportunity out of probation. Thank you.
All right. Any additional statements in regards to the other case?
Judge, just that it's essentially the same situation that she was going through when this case occurred, although the undiagnosed mental illness and such were having it run consecutive, I think gives her that incentive to make sure her probation is successful. Otherwise, she has a very long sentence in jail that she faces. So she has that incentive, and we just asked the court to place her on probation in that case also.
Ms. Meyer was to be getting mental health and evaluations and so forth in an earlier time, and she either I'm not sure if she followed through with that or if she didn't follow through with the recommendations. She's had 2 opportunities at the same probation and basically has pretty much violated every term, including a new law violation at this juncture. In regards to 300058, I'm going to revoke her probation in order she serve the sentence. She'll get credit on this case for the time that she served. In regards to the new case 192, I will place her, I will impose a 30-day sentence. I will order that be consecutive, and I'm denying probation. So she'll serve the remainder of her 6 months. She'll have an additional 30 days. I will direct the court costs and attorney's fees to her, the domestic violence fee of $100. I'm going to order that those be sent to collections, but she's had probation, she's had opportunities, and the probations were set up to help her deal with these issues that she had, and she chose not to do that. And I understand she may have some mental health issues, and certainly if that's been diagnosed, she needs to follow through with it. But for probation to have any effect, persons need to do it, and she really has, from what I can see, never really put much effort into getting it done. And so I'm denying the probation at this time. Anything further in regards to these cases?
Judge, the only request we'd have is the state do a request for jail time credit from the jail and include that on the journal entries, please.
Yes, if that could be done, that can make it a lot easier for them to calculate a release date and so forth. And I hope that she'll utilize mental health while she's there incarcerated. I believe there's arrangements made for that. So,
And Your Honor, just for purposes of clarification and finalizing the journal entry, is the court ordering credit for time served in the 25 case as well as the 2023 case?
well, they're consecutive, so she only gets credit for one or the other.
Very
So,
good.
yeah, she gets credit for every day that she's been in, and it can be calculated as to which one, but that's why she only has a 30-day sentence in regards to the new cases, because I don't think she's an appropriate candidate at this time for probation.
Very
So,
good, Your Honor.
very well. Yeah. This matter is adjourned. Jen, do we have any other matters?
Not that I'm aware of, Your Honor.
Thank you. Thank you, counsel. With that, we're adjourned.
Thank you, Judge.
Next case, State of Kansas versus Sydney Taylor Leslie, 25 CR 250. Good
Yes, Your Honor.
afternoon, Miss Leslie. Miss Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Though, then count 4, same date and location, failure to register vehicle, and unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel. If you cannot afford an attorney. Pardon me?
Excuse me. I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 and the doctrine of special appearance recognized in Kansas jurisprudence.
Okay. You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds. And
Court overrules the motion for dismissal of the case.
Court
overrules dismissal of the
prejudice
case.
And
the court will find that Miss Leslie, that the court does find it has jurisdiction to proceed, and subsequently the court
I
sets your next
object. You
appearance
called me
date.
a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias. And
No
it
prejudice or
declares
bias
for
is asserted
immediate
as to
dismissal of my
yourself.
case.
However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same. And the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Miss Leslie?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement. Okay, and what another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, that's proceeding, specifically, this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predeposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a shovel and search and confiscation of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi iridium, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Leslie.
Thank you, Your Honor.
And Mr. Sweeney, that's the last case I show on the first appearance docket.
Thank you, Your Honor.
Have a good day.
You too.
April Lynn Lyman. It's case number 2024 CR 396. Brett Sweeney appears for the state of Kansas. Darren Patterson is defense counsel. April Lyman appears from the Butler County Detention Center Zoom location. Matter comes before the court at this time for further hearing in regard to a warrant to show cause alleging probation violation. Court notes that this defendant was sentenced back on March the 4th on possession of marijuana and possession of paraphernalia charges with a 6-month consecutive sentence that was imposed for an overall controlling sentence of 12 months. Allegations including failing to report as directed, failing to make payments, not providing proof of an alcohol and drug evaluation, had law enforcement contact and did not report it, and then her reported address was incorrect. Mr. Patterson, what announcement is made regarding these allegations?
Your Honor, I have discussed these allegations with Ms. Lyman. I would tell the court she is going to waive hearing. She is going to stipulate that she did violate the terms of her probation.
Very well. April Lyman,
Yes.
your attorney has made an announcement that you would waive any due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You do have the right to challenge the state's evidence, to present your own evidence, have the advice and assistance of a lawyer, and confront the state's witnesses unless good cause was shown. Among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
And do you now waive any hearing in the case and stipulate and agree that you committed the violations as outlined on the record earlier by the court?
Yes, Your Honor.
Very well. Court finds that the defendant has knowingly and voluntarily waived a hearing in this case and stipulates and agrees that she committed the violations as alleged. They are significant and substantial and material violations of the terms and conditions of her probation. I'm going to ask for recommendations regarding an appropriate disposition. I will begin with Brett Sweeney on behalf of the state of Kansas.
Your Honor, the state is recommending a 3-day jail sanction, and then asking that she be placed back on. I don't know. I didn't discuss this with Mr. Bauer, but she might need maybe a bump up to community corrections. I don't know that that was necessarily negotiated with Mr. Patterson either, but essentially the state's recommendation is 3 days and then back on probation with the same and previously ordered conditions. I believe that she's been in, and Mr. Patterson, correct me if I'm wrong, April 28th, awaiting hearing on this warrant. She's done little to nothing on the probation. That's all I have, Your Honor.
Mr. Sweeney, are you aware that whether or not she has a felony action in which she's being supervised by community corrections?
I don't believe that she does. Now, Mr. Bauer may know this, but I believe that she's got some sort of involvements over in Sedgwick County. Now, I don't know if that just includes pending charges or whether there's supervision over there or not.
Mr. Bauer, do you know?
Your Honor, I'm unaware of her being on any felony supervision at this time. And since this was a misdemeanor case, she's not on felony supervision in our district. I don't know that a change to community corrections is something we can do at this point. Even if she was on community corrections in Sedgwick, they're a different district, so we wouldn't really be able to make them take a misdemeanor case from our district.
Thank you, Mr. Bauer. Mr. Patterson, your recommendations regarding an appropriate disposition here?
Judge, as the court noted, she was sentenced on March 4, and has been noted by Mr. Sweeney, she has been in jail since at least April 28th. And here we are on June 6th, so that she's been in jail about as long as she's been on probation or out on probation. She was unsuccessful to begin with, but she did explain to me that the situation concerning her address was that she had a domestic issue that caused her to not have a residence. She was in a motel for a little while trying to find place to live, and it was quite chaotic for her. I had a long conversation with her about, even though she is in a motel, she still needs to make sure her probation officer knows her whereabouts and addresses where she can be reached each and every night that she would lay her head down. The probation officer needs to know where she is located at. Judge, she has not done anything, but from the date of March 4 until April 28 when she was picked up, there was some time, but not a lot of time to do her probation. She has now been in custody for some time on this PV. Judge would ask the court to consider the 3-day sanction and reinstate probation. And she has assured me that she will make sure Mr. Bauer knows her whereabouts at all time, and that shouldn't be a problem going forward. Thank you, Judge.
Are you suggesting that the court not impose a prospective sanction here?
No, we're asking the court to adopt Mr. Sweeney's recommendation that it be a 3-day prospective sanction.
All right. I understand your position now, Mr. Patterson. Thank you. Mr. Bowers, do you have anything to add here?
Your Honor, I discussed this with Mr. Sweeney, and I am in agreement, if the court sees so to do, to give her a sanction, put her back on probation. I really think that treatment is something she probably needs, and that I think we need to give her an opportunity to try to get that treatment if she's willing to do it now. She had that opportunity initially. If she's going to follow through with that, I'm in agreement with that, but she also needs to understand that this is going to be a very short leash, that, so to say, that I will be allowing. I'm not going to tolerate a whole lot of putting off getting the stuff done or failed UAs or anything like that without bringing her back in front of Your Honor.
Very well. Thank you, Mr. Bauer. This time, the court will address April Lyman personally, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment here.
No, Your Honor.
Ms. Lyman, where would you be living if you got out?
I'm not sure of it right now, as far as I know, with my best friend.
Okay.
But I'm not sure his address. I can get it to you as soon as I find it out.
All right. Ms. Lyman, the court has previously found that these are substantial and material violations of your probation. You have already received a 1-year jail sentence from the court. That would not be a new thing. At the time of your sentencing, you received a year in jail. However, the court did grant an alternative to it by giving you an opportunity for probation, an opportunity you have not yet seized in any way. So you've got a fundamental decision to make, Ms. Lyman. Either you're going to do the probation period or you're going to do the jail time. I don't know why you'd rather do the jail time than the probation, but if that's what you choose, the court will make the order. But I would rather you choose meeting your probation conditions and perhaps getting some treatment help as part of it. Going to see Mr. Bauer regularly and doing what he directs you to do and what he helps you with. The court will impose a 3-day jail sanction for noncompliance with terms and conditions, prospective from today. So she'll be released about this time on Monday, back on court services probation. Because sentencing was relatively recent, I don't see the need for an extension currently. She's on until March 4 of 2026 at this point. Any unsatisfied condition remains to be satisfied. Ms. Lyman, how do you financially get by?
Well, I would have to get a job. I had to get a new ID and everything because that was stolen from me in the house that I was living in on Olive Street that I'm no longer allowed. So I don't have a birth certificate, social security card, or an ID, but I'd have to get all that before I can get a job. So that would be one of the main things after the assessment.
Well, you're obviously at a high degree of being financially challenged. The court notes that and will waive any additional attorney fee assessments. This doesn't relieve anything previously imposed, but I'm not going to add anything more to the obligations that have already been ordered to be paid in the case.
All right.
So what direction, Mr. Bauer, do you give April Lyman when she gets out on Monday?
Your Honor, I will be back in Butler on Wednesday of next week, June 11th. If she can come see me at 11:30 in the morning on June 11th, we will get her stuff going again.
Ms. Lyman, do you note that date and time?
Yes.
Next Wednesday, June 11th at 11:30 in the morning, you need to go see Mr. Bauer at his court services office in Butler County, okay?
Okay.
All right. Anything further on the Lyman matter, Mr. Patterson?
No, Your Honor.
Or Mr. Sweeney?
No, Your Honor.
Very well. Then the Lyman matter will be in recess at this time, and we'll move on to another matter on the docket.
Thank you, Judge. If I could be excused.
You are excused at this time, Mr. Patterson.
Have a good weekend.
You too. Mr. Watts looks like he's ready on both cases.
Good
Or is
afternoon,
he?
Your Honor. I have, I think, one who is Ms. Dennis. Don't believe I have any other.
You were
If I
appointed
missed
on Anthony Alfaro Jr. back on February 5.
Okay.
Let me look and see what subsequent
Oh,
notes would
hang
indicate.
on. Let me go get it. Find it.
All right. Mr. Watts, I think I might be able to assist here. The order I was referring to for warrant to show cause was back on February 5. There was a subsequent hearing on those allegations later in February with you representing the defendant. There was a first appearance before Judge Hutchison on May the 7th on this more recent set of allegations for Mr. Alfaro. The allegations were read. The defendant stated they are all fabricated and they all cost money and he doesn't work. And then the hearing was set on those allegations by Judge Hutchison before this court.
Okay.
I see no reference to appointment of counsel. I don't know why, but that may help explain why you weren't aware. Anthony Alfaro?
Yes, sir.
I actually, is that 24 CR 371?
That is correct.
Okay, I actually do have that file in front of me. And the show cause, so perhaps we can go ahead and take it up. I'll need to meet with Mr. Alfaro. I have spoke with Ms. Dennis, who is at court security, and I can take that one up right now.
Okay. Well, I hate to make the jail wait, but if we've got a case ready to present, then I want to address it. So we will shift. Mr. Alfaro, just be patient with us. We'll get back to you.
Yes, sir.
Court will take up State of Kansas versus Marie Elizabeth Dennis, case number 2024 CR 217. Brett Sweeney appearing for the state, James Watts as defense counsel, Marie Dennis appearing from a court security monitored location at the Butler County Judicial Center by Zoom. This matter comes before the court at this time for hearing on allegations that probation conditions have been violated by Ms. Dennis. Apparently, these allegations include the defendant failing to report as directed, and also unsuccessful discharge from alcohol and drug treatment, as alleged by Ms. Ashenfelter from Community Corrections. There's also an addendum to the original warrant, apparently alleging that the defendant was arrested for possession of opiate and possession of paraphernalia in Cedric County, and then she didn't notify her ISO of that, and that the defendant possessed a syringe with liquid methamphetamine per the Cedric County Sheriff case number. What announcement is made regarding Marie Dennis's case, Mr. Watts?
Judge, as to the original allegations of the warrant to show cause dated April 29, it's my understanding my client would agree that she failed to report on February 20 and the subsequent February 26 date. Would stipulate to that violation. She would also acknowledge that on February 27, she was unsuccessfully discharged from alcohol and drug treatment. She would note she is currently has a bed date for Monday to begin again that alcohol and drug treatment at Cherry Creek in Wichita. As to the addendums, my client would not acknowledge or stipulate that she failed to notify her ISO of law enforcement contact. In fact, her position is that she made contact with her probation officer immediately upon bonding out. It was one of the first things she did on bonding out on that case. And of course, she will not be stipulating possessing anything as a result of that incident as well.
All right, Mr. Sweeney, how does the state wish to proceed here?
Your Honor, the state is willing to proceed on the allegations that have been stipulated to. I might just briefly ask for the court's allowance to call Ms. Ashenfelter for some elaboration on what's been stipulated to, but I'm willing to proceed on that.
Very well. Apparently, the state wishes to call Ms. Ashenfelter for some brief testimony. Ms. Ashenfelter, if you join us fully and raise your right hand. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Mr. Sweeney?
Okay, thank you. Just briefly state your name for the court, please, ma'am.
Christy Ashenfelter,
And Ms. Ashenfelter, who you work for.
13th Judicial Community Corrections.
Okay, and Ms. Ashenfelter, Miss Marie Dennis came on to probation with you at what point, what date?
She was sentenced in January of this year, and then she was transferred to me shortly after that.
Okay, and in your warrant application, you listed that she failed to appear on a date in February. Is that accurate?
Yes.
What date was that?
February 20th.
Okay. Did she ever appear in your office or make communication with you after that date?
No, not until May of this year.
Okay. And was that February date? What was that, an intake date?
No, her intake would have been earlier with Deputy Director Kelly.
Okay. She didn't make contact with you again and then until May?
Correct. I met with her at the office during her intake and gave her a reporting card and date.
Okay.
From there.
Were you made aware or did you facilitate the treatment that's been reported here today? The new treatment?
No.
Okay. I don't think I have any further questions for Ms. Ashenfelter.
Mr. Watts, do you have additional questions for the witness?
No, Your Honor.
All right. Do you intend to present any further evidence, Mr. Sweeney?
No, Your Honor.
Mr. Watts, do you?
Judge, just on one thing, and I'll call Ms. Dennis.
All right, Ms. Dennis, you've been called as a witness by your attorney. If you'll raise your right hand, at this time I'll administer an oath to you. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yeah.
You may proceed, Mr. Watts.
Ms. Dennis, I'm only going to ask you about one thing. It was obviously your surprise, and after our conversation, my surprise. You're entering a facility on Monday, correct?
Yes, sir.
What facility is that?
Cherry Creek
Where is that?
in Wichita.
Have you informed or cooperated or worked with your probation officer regarding that treatment facility?
I told her at our last meeting that I had a bed date for Monday.
Okay. Did you give her any paperwork or documents regarding that facility?
No, but I don't have any myself to give to her.
Okay. Was she involved at all in arranging that facility entry?
She said she just wanted me to go to treatment. It didn't matter where I went as long as I went.
Okay. I have nothing else, Your Honor. Thank you.
Mr. Sweeney, any questions for the witness?
No, Your Honor.
All right. And any further evidence that you wish to present, Mr. Watts?
Not at this time, Your Honor. Thank you.
Okay. Closing remarks here and recommendations, Mr. Sweeney?
Your Honor, I'll just say this. It's the recommendation of the state that she serve the underlying sentence. This was a departure case from its genesis, meaning that, the legislature, when it enacted these departures and how they were going to interact with probation violations, didn't require diffs and sanctions of that sort. And I think the reason is clear. It's just they've been down this road before, and for that reason it kind of had to fly straight, and unfortunately it doesn't look like Ms. Dennis has, and for that reason the state's recommending revocation and serve the underlying balance of her sentence.
All right. Is there anything that you would add to that, Ms. Ashenfelter?
No, Your Honor, I agree with the state.
All right. Mr. Watts, your recommendations regarding an appropriate disposition here.
Judge, I would agree that there needs to be a sanction here, and it needs to be a relatively significant one. This is not a call for a dip. This is a call for a sanction in the 2-week to 30-day range. A significant sanction is significant county jail time. But this is not a time, in my opinion, to throw out the baby in the bathwater and everything else. Is she in violation? She is. And are those violations significant? They are. But she is also taking steps to remedy those violations with the entry at Cherry Creek. I'm afraid, although my client would like to enter that on Monday, I think that's probably not realistically likely because we all recognize there has to be a sanction at this point. The question is the severity of that sanction. We would recommend, as I said, something in the 2-week to 30-day range in the county jail, and that to begin immediately rather than simply remand to custody.
The recommendation is noted, counsel. What time on Monday was she really supposed to report to this facility in Wichita?
Ms. Dennis?
11 a.m.
All right, Ms. Dennis, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
I would just like to apologize. I know you gave me a big break back, at our last court, and I failed. But I'm trying to make things right.
Why didn't you try after your sentencing, Ms. Dennis?
Because when I first missed the first original and rescheduled with her on my meetings, when it came down to it, like after the one, I got scared. And my first reaction is to run. And normally that's what I do, is run. I don't face my problems, and I'm trying to do that now as an adult. I should have been doing this a long time ago. I'm just a little bit late, and I'm sorry for taking advantage of the situation.
Well, you're about 4.5 months late, actually, in getting your probation started appropriately.
I understand that.
Court looks back at this point at its docket notes from the sentencing. The sentence was for possession of methamphetamine, a level 5 drug felony. I think she was in the E-box. She received a 20-month DOC sentence. Dispositional departure was granted. Obviously, treatment being the focal point of that dispositional departure. I did make a specific statement. Defendant advised that no intermediate sanctions would be required if she faces a warrant to show cause. And here we are, facing a warrant to show cause, which stem from probation violations. Ms. Dennis, I don't know what's going to happen with this Citery County case number 2025-001-7835. The suggestion before the court is that you're in further trouble over there, but that's not been stipulated to, and the state's proceeded without those allegations. The court will just make the finding those were not litigated or dealt with in any way. So they remain. I have severe reservations about this, Ms. Dennis, but I do look at what your crime of conviction was in this case, and it was possession of the dangerous street drug of methamphetamine. Society profits if you beat this habit, but you have to want to do it, and you're going to have to follow through. And I'm not going to say for 1 minute any of it's going to be easy, but if there is an actual treatment bed available to you, I want you in that treatment bed. Court is going to order a sanction period of what will be functionally of approximately 3 days, but I do want her released in time to make her 11 o'clock appointment on Monday for the treatment facility. What would your transportation be over there, Ms. Dennis?
My dad will take me.
He'll be at the jail to pick you up at, say, 10 o'clock?
Yes, sir.
And get you over there by 11?
Yes.
All right, I'll authorize her release at 10 o'clock a.m. on Monday morning. At that point, she'll be reinstated on community corrections. Ms. Dennis, I hope you understand this is the last reinstatement you're going to likely get from this court.
Mhm.
I don't want to waste the valuable resources of community correction supervision on somebody who doesn't want to take advantage of the program.
I understand.
I can have Ms. Ashenfelter doing other things. So you will report to her as directed. Now, I presume that you can make phone calls from the treatment facility.
Yes, sir. Mhm.
And I'm going to want you to call Ms. Ashenfelter when you get there and get checked in. So sometime during that day, you tell them that the court ordered you to call your community corrections officer. And I trust, Ms. Ashenfelter, you would be there and available for a call on Monday at your office?
Yes, Your Honor.
Okay, does she have your number?
Yes.
Marie, you have that?
Yes, sir.
Okay, so I'm going to require you to call her. I want you, if she asks for any details regarding your program, location, how long you're expected to be in there, whatever it might be. She may have a whole series of questions she needs to ask you. So once you get checked in there on Monday, you need to call Christy Ashenfelter and fill her in on any of these new developments. Dennis, you need to complete this treatment program. You
I
can't
will.
go into this run mode that you seem to suggest that anytime pressure's on, you want to run. You run again, you come back before this court, you're likely going to be doing about 1.5 years in prison. And I don't know if you want to be there. Any unsatisfied condition of the original community corrections probation orders remains to be satisfied. If at this point they are unsatisfied, in light of the fact that Ms. Dennis is going to go into a treatment program, the court's not going to assess additional fees. I just don't think it's feasible for this court to expect that we can add more at this point. So I'll waive any additional bids assessments on this round of proceedings. Anything previously ordered, though, obviously remains. All right, the original sentencing order was January of 2025. 12 months probation. Ms. Ashenfelter, do you see the need for an extension at this point?
No, Your Honor. I can do one in the future if needed.
All right, I think that's the proper approach. All right, Ms. Dennis, you have any questions about the court's orders?
No, Your Honor.
Then I'm ordering you into custody at the Butler County Jail until release time, 10:00 a.m. on Monday, so that she can report to her inpatient treatment facility, which I presume this is an inpatient facility, right?
Yes. Yes, it is.
At 11:00 a.m. on Monday. Reinstatement of community corrections at that juncture. All right. Mr. Watts, anything further we need to address here?
I believe so, Your Honor. Ms. Alfaro, I would tell your treatment provider, if there are any documents for your entry, you need to be prepared to provide those to Ms. Ashenfelter.
Okay.
And she's Miss Dennis, by the way, but
I'm sorry? Oh, what'd I say?
you said Alfaro, but
Oh, I'm looking at the other file and right in front of me.
understood, Mr. Watson. I just want
I'm
the
sorry.
record to be clear. Mr. Sweeney, is there anything further we need to address?
No, Your Honor.
Ms. Ashenfelter, do you need any further clarification from the court at this time?
No, Your Honor.
Last but not least, Ms. Dennis, you have any questions about what we've done here?
No, Your Honor.
All right, you're going to go into custody at this time until
Thank
Monday at 10:00 a.m. There's nothing further. The Marie Dennis matter will be in recess. All right, let's set up a breakout session between Mr. Alfaro and Mr. Watts. I'll just ask Mr. Sweeney and Mr. Bauer to be patient. Thank you, gentlemen.
It should be ready for you guys.
Yep.
Randy, if we can resume recording and broadcasting.
Judge, I never took it off. I'm sorry.
Very well, then we will continue by calling State of Kansas versus Anthony Michael Alfaro Jr. It's case number 2024, CR 371. Brett Sweeney appearing for the State of Kansas. James Watts as defense counsel. Mr. Alfaro from the jail Zoom location. This matter comes before the court at this time for a review of this defendant's probation pursuant to a warrant to show cause alleging probation violation. The allegations include Mr. Alfaro not making any payments, not providing proof of a drug and alcohol evaluation, not updating his telephone number, testing presumptive positive for methamphetamine, has not gained employment, was convicted on new charges. What announcement is made at this time, Mr. Watts?
Your Honor, it's got the matter with my client. It's my understanding he would stipulate to the violations, that he'd not made any payments, done the drug and alcohol evaluation, has not updated his phone number. The reality is he doesn't have a phone to update. He did test positive for methamphetamine, although there was no confirmation of that. And again, and this is going to be a theme, Your Honor, that confirmation costs money that he does not have. He's not gained employment. He's been a long-term incarcerated in his prior history, so it's very difficult to get employment in a community where you are a long-term recent release from the Department of Corrections. And of course, he's obviously would stipulate to new charges. Those are coming up for sentencing shortly. He had not made any payments. Judge, the recurring issue for Mr. Alfaro in this case is a very simple one. His house has no water, no electricity. He has no transportation. He's riding a bike. He has no income. He has no ability really to get that income, in that his status as an ex-convict is very difficult to get employment. And all the things they're asking him to do, for the most part, require him to have some income that he simply does not have. As I mentioned for a moment ago, updated his phone number. He can't update his phone number. He doesn't have a phone. So he would stipulate to the violations. I would also note he is a trustee there in the jail. He's working on a GED there. I think, in fact, completed a GED there. He's got going to AA and NA, so there is some hope there. But he would stipulate to the violations.
Very well. Mr. Alfaro.
Yes,
Your
sir.
attorney has indicated that you would now waive any formal due process hearing that you'd be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You would have the right to present your own evidence, challenge the state's evidence with the assistance of your lawyer, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of the 12-month jail sentence that you're currently under. So, is it your intention to waive a formal hearing in this case and stipulate and agree that you committed these violations, which the court outlined earlier? Anthony? Mr. Alfaro, I will need a response.
We will do. I don't know what to do. I'm on city and county probation. I have an ex-con. They want me to do treatment, mental health. They want me to pay for the UAs. If I can't pay for them, they're dirty automatically. They want me to pay the fines. The city's on me for my house not being the code, sir. All the things that they want me to do is what they want. You did order them, sir, and I don't mean no disrespect by no means. All due respect, sir. But there's so many things they want me to do. I don't have the money for them. I'm not trying to, I'm just burnt. I'm stressed. And yeah, I couldn't, I smoked a week before that UA. I don't know how it became dirty. It was a week and a half before me, sorry. But I did smoke because I was stressed out. And I just, sir, all due respect, I just don't know what else to do. I got all this time hanging on me. I don't hurt nobody. I'm not trying to hurt nobody. And what you see is this is me. I want a new life, and I can't have a life here because I keep getting in trouble. And it's little petty shit that keeps building up. And sir, all due respect, but I don't know what to do. But sit here in jail. That's all I ever done was do time for people that want me to do this and that and this. And I don't hurt nobody. But other than that, sir, all I can do is be at your mercy.
Okay, well, We were at an earlier stage than disposition, Mr. Alfaro.
Yes, sir.
Your attorney had announced that you intend to waive a hearing and
Yes,
agree
sir.
that you committed these violations.
Yes, sir. Yes, sir.
And you agree with your attorney's statement, is that correct?
Yes, sir.
All right. Court does find that there's been a voluntary waiver of a hearing in this case and that the defendant does stipulate and agree that he committed the violations. These are substantial material violations of the terms and conditions of Mr. Alfaro's probation. Before I take any formal recommendations, I wish to inquire, Mr. Sweeney, do you have a handle on how many accrued jail time days this defendant has?
Your Honor, I don't know that I have a handle on that, considering that it was a misdemeanor that this was pled to. And I don't believe that an accumulation of jail time credit was put in to that misdemeanor journal entry. I can tell the court that it looks like, no, I know he's got the other case that's set for sentencing on the 26th in front of Judge Hart. But he did have a first appearance on this warrant to show cause on May 7th. I'm sure the court has that in the court's file as well. So it looks like at least probably 30 days or so, 29, 30 days with a hold on this case. So that's at least, that's about what I can say for sure.
All right. Well, my docket notes indicate from October 30 of 2024, I made a note that he had approximately 3 months jail time credit then.
Your Honor.
Yes, Mr. Bauer.
Based on the records I have, when he went into custody, I put it into our system and he was picked up on this warrant only. So this time has only been on this case. And based on that, I show he's got 33 days of credit on this show cause warrant.
All right. Thank you.
Prior to that, I am not sure.
Recommendations regarding an appropriate disposition, Mr. Sweeney.
Thank you, Your Honor. Well, to the court's question, essentially, Mr. Bauer and I had a discussion about Mr. Alfaro's case prior to today's hearing. And I think generally what I took from that is not real optimistic that he would ever, well, I don't know. Not optimistic that maybe he would succeed on this probation. But he does have the felony sentencing coming up in front of Judge Hart, in which I believe a departure motion has just been filed. That's set for June 26th. So what Mr. Bauer and I had talked about was doing or asking the court rather to do a modification to a modified sentence that would end on June 26th. With whatever jail time credit that is, and it sounds like maybe he had about 3 months plus an additional, it sounds like Mr. Bauer was thinking 33 days. That would be a massive modification off an original 12-month sentence. But then he could make a departure motion, and I don't know what will happen there, but he's an A on the grid. And but I just think with that pending felony coming up, that may be a way to close this case out for what we see has been an unsuccessful probation.
Mr. Wallace, I'm interested in how you see this proposal.
Judge, I'll be honest with you, I think that's a very fair proposal. He is up for sentencing in the other case on March 26th. We'll be filing a departure motion in that case. As you might guess, it's a departure that's a little bit of an uphill battle for the circumstances we've just talked about right here today. I won't pretend otherwise. I have no idea what Judge Hart's going to do on that case, of course, but frankly, it sounds to me like a relatively reasonable outcome. If Judge Hart would grant the departure, it would give him an opportunity to get a fresh start at that time with a felony probation and a drug treatment program as part of that. If he does
what is
not,
the primary crime there?
That is a possession of opiate. I don't remember what the underlying offense was. Hang on one moment, I can tell you.
It's possession of meth.
Methamphetamine, possession of meth, yeah. So if the court would not grant the departure, he would end up in the Department of Corrections in any case.
What's his bond status in that case, Mr. Watts?
Judge, he's obviously in custody in this case right now. I don't know that he'd made bond in that case. It's a $2,000 cash or surety. I was out when they actually pled on that case. Mr. Favre took that case. I was out that short when my mom had passed away. So I was not here at that time.
Sorry to hear that, Mr. Watt.
That was back in March.
Sorry to hear that.
So I didn't take the plea. Mr. Favre did.
Your Honor,
Mr. Bauer.
Mr. Alfaro made bond on that felony case.
Okay.
And then later this warrant was issued and he was picked up on this. So he is on bond in that case.
Okay.
This time, the court will address the defendant, Anthony Alfaro, personally and ask him if he has any further statements that he wishes to make in mitigation of punishment. Mr. Alfaro?
I just ask, thank you for your time and hearing the case and looking at all the evidence. And I just ask for a chance, one more chance. That's all.
All right. Mr. Alfaro, I'll just make a couple of observations here.
Yes, sir.
Part of the problem you have with employability and things like that are, of course, because of you and your judgments in the past.
Yes,
And
sir.
unfortunately, they're still following you around. And I'm sure it is very difficult for a convicted felon, especially somebody with an A-box record, to get a job, a good job, to support themselves.
There's good people out there.
I have no doubt, Mr. Alfaro. Further, your continued involvement with illegal street drugs disturbs me some. I understand the stresses you're under, but you have to deal with stress that's not dealing with illegal street drugs. And apparently the indications are you're still being involved with it. That troubles the court, certainly. However, Mr. Alfaro, with all of the lamenting that you've done before the court, perhaps very justifiable, I actually believe you. I think you're being straight with the court about what your situation is. Again, a bed of your own making, but nevertheless, a very difficult one to lie in. And this court is inclined to enter an order that I'm not sure I've ever entered into in 20 years on the bench. And I even question whether in a technical sense, all would agree that it's a proper sentence. But I also recognize, counsel, the possibility of a continuance of the felony sentencing, and I'm simply not comfortable letting Mr. Alfaro out until his felony case is resolved through sentencing. Now, this court will observe that he's probably served about 4 months of a 12-month controlling sentence. Therefore, if this felony sentencing takes place anytime in the next 8 months, it would be covered by the original sentencing order. However, this court will grant relief under KSA 223716, and I will modify the sentence that when Judge Hart or another district judge pronounces sentence in the felony case, I will terminate this case. I will consider this case fully served. And I know that the net effect of that, Mr. Alfaro, might mean that you get probation from Judge Hart and you get another chance. But I don't want you tied up in this case's jail sentence when you have an opportunity perhaps for some treatment program in the community. That is, of course, that's what Judge Hart feels is in the interest of justice. And with you being in the A box, I kind of agree with Mr. Watts. It's a fair assessment that I think that's going to be an uphill battle. But nevertheless, you should have that opportunity to make that argument in felony court and to benefit from whatever sentence that is imposed that might be mitigated to some degree. So I don't like the uncertainty of the time that I'm requiring here, but I'm just going to have him held up to 12 months in the county jail, but certainly no longer than that, or until Judge Hart actually pronounces sentence in his felony case. At that point, when that sentence is pronounced, this case is terminated as far as jail sanction is concerned, and his case will be closed. The court will also, after some reconsideration of this defendant's financial circumstances, will remove any bids assessments from his ledger. This court originally imposed $350 in bids assessments. Those are removed. Those are no longer due and payable. That needs to be reflected by the journal entry stemming from today, Mr. Sweeney.
Yes, Your Honor.
Anything else that was assessed at time of original sentencing that's not paid remains. I'm only taking off the bids assessments.
Okay.
And those are immediately due and payable and can be sent to collections.
So, Your Honor, no new fees, and then the initial bids fees are removed, but
That
not.
is correct.
Okay.
That is correct. I don't know what that leaves as far as his balance. Tony, can you tell us that? I mean, I don't know if he made any payments on the case or not.
There's not been any payments on the case, so
Okay.
that would just leave the court costs and court service fee, the $60
Yes.
probation fee.
Okay, well, those still remain on his ledger to be collected. Someday you're gonna have to pay him, Mr. Alfaro. Hope you've got a good job in the community someday and you can pay everything.
Yeah, that'd be awesome.
It can happen. I've seen it before.
Yes.
And you're way too young to give up on yourself.
Thank you.
All right. I think that's a fairly simple order. Mr. Watts, do you need any further clarification or need for additional rulings?
Your Honor, thank you.
Mr. Sweeney, I do appreciate your reasonable position that you and Mr. Bauer have taken regarding this case. It does seem to make good practical sense to address the case in the manner that we have. But do you have any further need for rulings from the court at this time, Mr. Sweeney?
No, Your Honor.
Mr. Bauer, essentially, I've taken you out of this case. You can essentially close your file on Mr. Alfaro. And Mr. Alfaro, I still think you can make it out there in the real world.
Thank you.
And I hope you get that opportunity someday.
Thank you.
And seize that opportunity. So I'll remand his custody back to the Butler County Jail until such point in time that Judge Hart has actually imposed a felony sentence in his pending felony case. All right. And I'm sure the jail may be calling me about this at some point. Who knows? I'll try to clarify it for him. And good luck in the drafting of an appropriate provision in the journal entry, Mr. Sweeney. I know that you'll use all of your creative writing talents to carry out the intent of the court.
I'll try, Your Honor. Thank you.
I know you will. If there's nothing further then.
Thank you,
The
sir.
Michael Alfaro Jr. matter is currently in recess. And I think that concludes the docket. Do you agree, Mr. Sweeney?
Yes, Your Honor.
Very well. Then the meeting may be ended for all at this time.